So let's talk about the revised Penal Code Article 21 to Article 40. First, the Article 21. No felony shall be punishable by any penalty not prescribed by law prior to its commission. In short, this article states that walang penalty or batas ang maaaring ipataw or iparusa sa isang krimen kung ito ay hindi pa nagagawa bago nangyari ang isang krimen. As the Latin phrase says, nullum crimen nulla pena sine lege, there is no crime where there is no law punishing it. For example, A was charged with fraud or infringement of literary rights or property because A allegedly reproduced and sold fraudulent copies of another's literary work. At that time, we had no copyright law. Question: can A be punished for such act? The answer is no, because there was no law at that time defining and punishing such an act. So let's move on Article 22, which is the retroactive effect of penal laws. Penal laws have a retroactive effect insofar as they favor the persons guilty of a felony who is a habitual criminal, as this term is defined in Rule 5 of Article 62 of this Code. Although at that time of publication of the such laws, a final sentence has been pronounced and the convict is serving the same. In general rule, ang retroactive effect ay ang pagtingin ng batas pabalik, which is hindi naman ito dapat applicable. Because according to the general rule, the law is always to look forward or prospective. For example, paano kung the next day, June 6, year 2022 ay nagkaroon ng batas na bawal lumabas sa classroom kapag nagkaklase? Question: what will happen to those students na lumalabas sa classroom nung hindi pa nagagawa ang batas? The answer is, sila po ay mananatiling inosente sa panahong iyon dahil noong ginawa nila ang leaving of classroom while in class ay hindi pa nagagawa ang batas. We must remember that the law application is always to look forward and not backward. Next is the Article 23, which is the effect of pardon by the offended party. A pardon by the offended party does not extinguish criminal action except as provided in the Article 344 of this Code, but civil liability with regard to the interest of the injured party is extinguished by his express waiver. In here, even if the injured party already pardoned the offender, the fiscal can still prosecute the offender. Why? Because a crime committed is an offense against the state, and in criminal cases, the intervention of the aggrieved parties is limited to being witness for the prosecution, and only the chief executive can pardon the offenders, except as provided in Article 344 of this Code. For example, the offended party in the crimes of adultery and concubinage cannot institute criminal prosecution if he shall have consented or pardoned the offenders. The pardon here may be implied as continued in action of the offended party after learning of the offense. It also requires that both offenders must be pardoned by the offended party. In the crimes of seduction, abduction, rape, or acts of lasciviousness, there shall be no criminal prosecution if the offender has been expressly pardoned by the offended party or her parents, grandparents, or guardian, as the case may be. Pardoned here must be expressed. Article 24. Measures of prevention or safety which are not considered penalties. And here are the following which are not considered as penalties. First is the arrest and temporary detention of accused persons, as well as their detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. Second is the commitment of a minor to any of the institutions mentioned in Article 80 and for the purpose specified herein. Third, suspension from the employment or public office during the trial or in order to institute proceedings. Fourth is the fines and other corrective measures which, in the exercise of their administrative or disciplinary powers, superior officials may impose upon their subordinates. Lastly, the provision of rights and the reparations which the civil law may establish in penal form. In paragraph 1, hindi ito tumutukoy sa tao na na-confine because of insanity and imbecility, but it refers to those accused person na na-detain because of insanity and imbecility. So why are they not considered penalties? It is because they are not imposed as a result of judicial proceedings. Meaning, yung pag-detain and pag-arrest ng isang tao, for example, is hindi yun effect or result ng judicial proceedings. Those mentioned in paragraph 1, 3, and 4 are merely preventive measures before conviction of offenders. They are just merely preventive measures and not hindi sila penalties. These are measures na ginawa before makonvict yung offender. So let's move on to the penalties which may be imposed of the Article 25. Here are the penalties which may be imposed according to this code and their different classes. So here are the scale of principal penalties. First, we have the capital punishment, which is death. Second, the afflictive penalties, which are reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison mayor. Third is the correctional penalties, which are prison, correctional, arresto mayor, suspension, and distero. And these are the light felonies, arresto menor, and public censure. We also have penalties common to the three preceding classes: fine and bond to keep the peace. And we also have accessory penalties: perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, the right to vote and to be voted for the profession or calling, civil interdiction, indemnification, forfeiture or confiscation of instruments and proceeds of the offense, payment of costs. We must remember na if wala sa R.P.C ang penalty na inimpose ay that will be served as invalid or void because it is not provided under the R.P.C. For example, the judge contended that puputulan niya ng kamay ang offender kasi nagnakaw siya, which is not valid because it is not provided under the revised penal code. Another example is the penalty of labor in addition of imprisonment cannot be imposed because it is not imposed by the R.P.C, which is cited in the case of U.S. versus Mendoza. Dito sa Article 25, it classifies penalties into principal and accessories. So, ano ang kaibahan ng principal penalties sa accessory penalties? Ang principal penalties are those expressly imposed by the court in the judgment of conviction. So these are the penalties na na-impose or na-render na. While the accessory penalties are those that are deemed included in the imposition of the principal penalties. So kahit hindi na-impose or in-include sa kanyang decision, yung ganitong penalties ay nag-e-exist pa din siya kasi nga it follows the principal penalties. And ang principal penalties may be classified according their divisibility. So we have divisible and indivisible. So ano nga ba ang kaibahan ng divisible and indivisible penalties? So here is the definition of indivisible penalties. Indivisible penalties are those which have no fixed duration. For example, the penalties of death, reclusion perpetua, perpetual, absolute, or special disqualification, and public censure. And while ang divisible penalties ay fixed durations and are divisible into three periods, from the word itself, divisible. And now let's go to the classification of penalties according to subject matter. First is the corporal, for example is death. Deprivation of freedom, example is the reclusion, prison, and arresto. Third is the restriction of freedom and destierro. So what is the difference between deprivation of freedom from restriction of freedom? Deprivation of freedom, for example, is na-detain ka, na-deprive yung freedom mo. While restriction of freedom is may restriction or you are restricted to do something. For example, sa series ng broken marriage vow ng ABS-CBN, dahil sa kasalanan na nagawa ni David, he is restricted na lumapit sa kanyang anak na si Gio ng 25 meters something, ganon. May freedom ka pero limited or restricted. As we go on, the fourth subject matter is the deprivation of rights. For example, is disqualification and suspension. Fifth, or the last is pecuniary, and the example of this is fine. And let's go to classification of penalties according to their gravity. Here are the penalties: capital, afflictive, correctional, and light. These are the penalties mentioned a while back that classifies into felonies under Article 9, into grave, less grave, and light felonies. So let's move on to the penalties that are either principal or accessory. First, perpetual or temporary absolute disqualification. Second, perpetual or temporary special disqualification. Third, suspension that may be principal or accessory penalties because they fall under the two general classes. So, public censure. Public censure is a penalty. Censure being a penalty is not proper for acquittal, as cited in the case of People versus Avelera. Again, remember that penalties that are not included in this law are considered invalid or illegal because it is not provided under the R.P.C or the Revised Penal Code. Let's move on to Article 26. When afflictive, correctional, or light penalty, a fine, whether imposed as a single or as an alternative penalty, shall be considered an afflictive penalty. In this article, there are different categories of fine as a penalty. First is the afflictive. If it exceeds 1,200,000 pesos. Second is the correctional if it does not exceed 1,200,000 pesos but is not less than 40,000 pesos. Third is the light penalty if it be less than 40,000 pesos. So note that if prescription of penalty, it is considered correctional penalty, and if prescription of felony, it is considered as light penalty. Now let's go to whether imposed as a single or as an alternative penalty. For example, is in Article 144, punishing disturbance of proceedings, the penalty is Arresto mayor or a fine ranging from 40,000 pesos to 200,000 pesos. Again, if the fine is over 1,200,000 pesos, it is afflictive. And if the fine is 40,000 to 1,200,000 pesos, it is correctional. And if the fine is less than 40,000 pesos, it is light penalty. So let's move on to Article 27 of the Revised Penal Code. Article 27 talks about the duration of penalties. So here are the durations of the penalties. First is the penalty of reclusion perpetua. The penalty of reclusion perpetua shall be from 20 years and 1 day to 40 years. The penalty of reclusion temporal shall be from 12 years and 1 day to 20 years. The duration of the penalties of prision mayor and temporary disqualification shall be from 6 years and 1 day to 12 years, except when the penalty of disqualification is imposed as an accessory penalty, in which case its duration shall be that of the principal penalty. The duration of the penalties of prison correctional, suspension, and destierro shall be from 6 months and 1 day to 6 years. except when suspension is imposed as an accessory penalty, in which case the duration shall be that of the principal penalty. The duration of the penalty of Arresto menor shall be from 1 month and 1 day to 6 months, while the duration of penalty of the Arresto menor shall be from 1 day to 30 days, while the bond to keep the peace shall be required to cover such period of time as the court may determine. For example, if pinatawan ka ng penalty na reclusion perpetua, makukulong ka ng from 20 years and 1 day to 40 years, na ganon. So let's move on to Article 28, the computation of penalties. If the offender shall be in prison, the term of the duration of the temporary penalties shall be computed from the day on which the judgment of conviction shall have become final. If the offender be not in prison, the term of the duration of the penalty consisting of deprivation of liberty shall be computed from the day that the offender is placed at the disposal of the judicial authorities for the enforcement of the penalty. The duration of the other penalties shall be computed only from the day on which the defendant commences to serve his sentence. So here, there are 3 rules on how to compute the penalties of the offender as stated in this article. The director or the prisons or the warden should compute the penalty imposed upon the convict of serving temporary rule. So the first rule is when the offender is in prison. The duration of temporary penalties is from the date of which the judgment of which conviction becomes final. So kapag ni-prison ka na ang offender, yung duration ng temporary penalties. Take note that we are talking here temporary. So the duration of temporary penalty will only start after the judgment of conviction becomes final. So what is the reason sa rule na to? It is because temporary detention of the accused is not considered as penalty and it is only considered as preventive measures. So hindi mag-start yung penalty mo unless after the final judgment. So let's go to the second rule. When the offender is not in prison, the duration of penalty consisting in deprivation of liberty is from the day that the offender is placed at the disposal of judicial authorities for the enforcement of the penalty. Here in rule number 2, we are talking about the duration of penalties consisting deprivation of liberty. Ito yung penalty na deprive yung freedom mo or freedom ng offender or accused. Mag-i-start yung computation ng isang offender na wala sa kulungan kapag nilagay na siya sa disposal or sa kulungan. So let's proceed sa third rule, which is the duration of other penalties. The duration is from the day on which the offender commences to serve his sentence. These are the penalties such as suspension. For example, if the accused who was in custody appealed his service of sentence should commence from the date of the promulgation of the decision of the appellate court, not from the date of the judgments of the trial court was promulgated. This was cited on Ocampo versus CA. So these are the instances where the accused can appeal. For example, meron nang na-render na judgment under lower court, tapos nag-appeal yung accused and his case went to Court of Appeals. Yung start ng sentence niya is hindi pa mag-i-start dun sa final judgment ng lower court, but it will start kapag may decision na sa CA. The accused could not be considered as committed or placed in jail by virtue of the decision of the Court of Appeals, although he was already in jail when the judgment was received. The fact of his custody as a mere appellant pending appeal continued, and the receipt of the decision of the Court of Appeals did not change the detention of the accused into service of the judgment. The reading of the sentence of the Court of Appeals to the accused was still a necessary step previous to the actual commitment of the accused. This was cited on the case of People versus Enriquez. Now let's go to the examples of temporary penalties. So sabi sa rule number 1, the duration of temporary penalties. So what are the example of temporary penalties? These are the temporary absolute disqualification, temporary special disqualification, and suspension. Then rules in cases of temporary penalties. If an offender under detention as when he is undergoing preventive imprisonment, rule number 1 applies. If not under detention because the offender has been released on bail, rule number 3 applies. When the offender is not in prison, rule number 2 applies. So let's go on Article 29. Period of preventive imprisonment deducted from term of imprisonment. So here, offenders or accused who have undergone preventive imprisonment shall be credited in the service of their sentence consisting of deprivation of liberty, with the full time during which they have undergone preventive imprisonment if the detention prisoner agrees voluntarily in writing after being informed of the effects thereof and with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners, except in the following cases, of course, when they are recidivists or have been convicted previously twice or more times of any crime, and when upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. This topic is about the offender or accused which undergone detention for some days, years, or months. Yung time na na-render niya sa jail sa kanyang detention is mababawas sa kanyang final judgment. For example, kung 10 years yung final sentence niya and naka-render na siya ng 1 year sa kanyang detention, magiging 9 years na lang ang kanyang final sentence. So ano nga ba ang mga rason for detention? Some, because wala siyang pang-bail, and the other one is hindi bailable ang kanyang kaso. So credit for preventive imprisonment for the penalty of reclusion perpetua shall be deducted from 30 years. This was included in Republic Act No. 10592. This amendment clarified that the crediting of preventive imprisonment shall likewise extend to those who have been sentenced to reclusion perpetua, and that credit shall be deducted from 30 years. Thus, if the offense for which the offender is undergoing preventive imprisonment is punishable by imprisonment or a fine, and upon conviction the court imposed on him only a fine, there is no credit to be given. For example, A was accused of violation of Article 143 of the R.P.C. The penalty provided for an article is prison, correctional, or a fine from 40,000 to 400,000 or both. During the presidency of his trial, A was detained for 10 years. Having been found guilty, A was sentenced to pay a fine 40,000 pesos. Can A successfully claim that his fine should be reduced because of his preventive imprisonment for 10 days? The answer is no, because his sentence does not consist in deprivation of liberty. So again, deduction is only applicable which consists deprivation of liberty. But what about distero? Distero is not deprivation of liberty, but nalilimit lang yung freedom mo. Although distero does not constitute imprisonment, it is nonetheless a deprivation of liberty. It follows that Article 29 is applicable when the penalty is distero. The accused should be credited when the time during which he has undergone preventive imprisonment. This was cited on the case of People versus Bastasa. Now let's go to convict to be released immediately if the penalty imposed after trial is less than the full time or 4/5 of the preventive imprisonment. Thus, if A been detained for 5 months and 10 days pending his trial for less serious physical injuries, and after trial he is sentenced to 4 months of Arresto menor, he should be released immediately. So dito, kapag na-detain ng isang tao and na-render ng judgment ng court, and then yung judgment ng court ay equivalent to more than or full-time or 4/5 ng na-render ng offender sa kanyang detention, ay ma-release na yung offender. So let's talk about Article 30. It talks about the effects of the penalties according to their respective nature. So, effects of penalties of perpetual or temporary absolute disqualification. The penalties of perpetual or temporary absolute disqualification for public office shall produce the following effects. Number 1, the deprivation of the public offices and employments which the offender may have held, even if conferred by popular election. Number 2, the deprivation of the right to vote in any election for any popular elective office or to be elected to such office. Number 3, the disqualification for the offices or public employments and for the exercise of any of the rights mentioned. And in case of temporary disqualification, such disqualification as is comprised in paragraphs 2 and 3 of this article shall last during the term of the sentence. Number 4, the loss of all rights to retirement pay or other pension for any office formerly held. So sa first paragraph, the deprivation of the public offices and employments which the offender may have held even if conferred by popular election. So kapag pinataw sa inyo itong perpetual or temporary absolute disqualification, yung offender is hindi na maaaring bumalik pa sa kanyang public office or employment. So madideprive na siya sa pagpapatuloy ng kanyang ginagawa. Let's go to the second paragraph. The deprivation of the right to vote is in any election for any popular elective office or to be elected to such office. So here, kapag napatawan ka ng perpetual, ay madidisqualified ka ng bumoto and to be voted. Next, paragraph 3. The disqualification of the office of public employment and for the exercise of any of rights mentioned. So, madidisqualify ka na din sa public employment mo. And in case of temporary disqualification as is comprised in paragraph 2 and 3 of this article shall last during the term of the sentence. So this penalty will end until the duration sa sentence na binigay sa inyo ng court. And lastly, the loss of all rights to retirement pay of other pension or any office formerly held. So what is the difference of temporary and perpetual? Temporary, it has a duration. Temporary lang siya. While perpetual, continuous naman siya. So, let's move on to Article 31. It talks about the effects of the penalties of perpetual or temporary special disqualification. Here, the penalties of perpetual or temporary special disqualification for public office, profession, or calling shall produce the following effects. First is the deprivation of the office, employment, profession, or calling affected. Second, the disqualification for holding similar offices or employments either perpetually or during the term of the sentence, according to the extent of such disqualification. Under paragraph 1, madideprive ang accused or the offender sa kanyang office of employment. And the second one, disqualification will last until the extent of such disqualification. The paragraph 1 refers to the deprivation of continually hold public office or to continue exercise a particular profession or calling. The second paragraph refers to the deprivation to hold or from being employed or employment. Here, bawal ka nang ma-employ or ma-hire sa similar office na yon, and yung duration niya is until matapos yung sentence na naibigay sa'yo. So, if a doctor is giving false medication or prescription at napatawan siya ng temporary special disqualification, such accused will be deprived from exercising his profession as a doctor. So next is the Article 32, the effects of the penalties of perpetual or temporary special disqualification for the exercise of the right of the suffrage. So first, what is the right of suffrage? Right of suffrage means the right to vote and to be voted upon. These are the rights na nakapagpipili tayo ng malaya kung sino ang gusto nating iboto at kung gusto nating tumakbo. A person who is suffering from temporary special disqualification for the exercise of the right of suffrage is disqualified from running from public office. It consequently deprives the convict the right to vote or to be elected or to hold office perpetually, and even to grant of absolute pardon to the convict will not erase this disqualification unless the right is expressly restored by the chief executive. So next is Article 33, the effects of the penalties of suspension from any public office, profession or calling or the right of suffrage. So the suspension is pwede nang i-impose even wala pang final judgment ang court or pending pa ang kaso mo. And this will not considered as penalty but rather a preventive measures which is cited under Article 24. So when suspension is imposed either as principal of penalty or as an accessory penalty, it will have the effect of prohibiting the conflict from holding public office or from exercising of his rights of suffrage during the period of the suspension. So meaning, made-deprive yung rights mo to continue your work or calling and also yung rights mo to suffrage. Next is the Article 34, the civil interdiction. Civil interdiction shall deprive the offender during the time of his sentence of the rights of parental authority or guardianship, either as to the person or property of any ward, of marital authority, of the right to manage his property, and of the right to dispose of such property by any act or any conveyance inter vivos. So what does it mean by inter vivos muna? Inter vivos is a gift made during one's lifetime. So dito, bawal ka nang mag-dispose ng property or by any act inter vivos or during your lifetime. While mortis causa naman is giving of the gift is made in the expectation of approaching death. So here parang mag-i-interfere siya sa civil rights mo such as parental rights and others. So yung mga rights na yon is made-deprive ka na ipagpatuloy itong mga rights mo. Next is the Article 35, the effects of bond to keep the peace. It shall be the duty of any person sentenced to give bond to keep the peace, to present two sufficient sureties who shall undertake that such people will not commit the offense sought to be prevented, and that in case such offense be committed, they will pay the amount determined by the court in its judgment, or otherwise to deposit such amount in the office of the clerk of the court to guarantee said undertaking. So it talks about the bond to keep the peace. It takes na duty ng isang tao kung saan na-sentencean siya na magbigay ng bond to keep the peace. The peace ng dalawang sureties. So ang dalawang tao na magbibigay ng bond to keep the peace ay sila ang magbabayad ng fines na hindi na prevent ng court na mangyari, which will be determined by the court. Yung pag-impose ng bond is ginawa for the purpose na masiguro na hindi na mauulit ang offense na yon. Understand? Ay. Article 36. It talks about the pardon and its effects. A pardon shall not work the restoration of right to hold public office or the right to suffrage, unless such rights be expressly restored by the terms of a pardon. So first, what is pardon? A pardon, it is an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment which the law inflicts for a crime. So, again, hindi pa pwedeng mabigyan ng pardon ang offender kung pending pa or on the process pa lang ang kanyang kaso. So, what is the effect of the pardon by the President? So based on Article 36, it states that a pardon shall not restore the right to hold public office or the right of suffrage. So kapag ibinigay ni President ang pardon sa isang offender, it doesn't mean na maibabalik na sa kanya ang right niya na makapagpatuloy sa public office or his right to suffrage. But there is an exception to this rule. When any or both such right is or are expressly restored by the terms of the pardon. Number 2, it shall not exempt the culprit from the payment of the civil indemnity. The pardon cannot make an exception to this rule. So kapag nagbigay ng pardon ang President, It will not include the civil indemnity na nakaakibat sa kaso ng isang offender. For example, yung penalty niya is nakakulong siya ng 10 years and may babayaran siya na indemnity dahil sa damage na nagawa niya sa offended party, which is worth 10K. So if nagbigay ng pardon ang president, yung 10 years imprisonment lang ang mapapardon. Hindi included doon ang kanyang 10,000 pesos na civil indemnity. Ibig sabihin, magbabayad pa rin ang offender sa offended party. And there are limitations upon the exercise of pardoning power. First is that the power can be exercised only after conviction. It is not applicable to pending cases. We must remember that. Second, that such power does not extend to cases of impeachment. Yung mga kasong impeachment ay hindi pwedeng ipardon din. Pardon granted in general terms does not include accessory penalty. When the principal penalty is remitted by person, only the effect of the principal penalty is extinguished but not the accessory penalties attached to it. For instance, a person sentenced to prison mayor is pardoned by the president. Such pardon does not restore to the ex-convict the right to vote unless such right be expressly restored by the terms of the pardon. Exception to this rule: when an absolute pardon is granted after the term of imprisonment has expired, it removes all that is left of the consequence of conviction. Now let us distinguish the pardon which is given by the president and by the offended party. So ano nga ba ang kaibahan ng mga pardon na to? First is, pardon by the chief executive extinguishes the criminal liability of the offender. Such is not the case when the pardon is given by the offended party. So, kapag nagbigay na yung president ng pardon na-extinguish na ang criminal liability ng isang offender. However, kapag nagbigay ng pardon ng offended party, hindi yun ma-extinguish yung criminal liability ng isang offender. Second is, the pardon by the chief executive cannot include the civil liability imposed, but the offended party can waive the civil liability imposed. So kapag yung pardon binigay ng chief executive, hindi ito masasali yung civil liability ng isang offender. So yung criminal liability lang yung mawawala. But kung ang nagbigay ng pardon is yung offended party, ay pwede niyang i-waive ang civil liability ng isang offender. So therefore, pwede niya ma-extinguish yung civil liability na babayaran ng offender. Third is, in cases where the law allows pardon by the offended party, the pardon should be given before the institution of criminal prosecution and must be extended to both offenders, whereas pardon by the chief executive is granted only after conviction and may be extended to any of the offenders. Here, kapag yung pardon ibinigay ng offended party, dapat yung ibinigay na pardon is ginawa niya prior to the institution of the criminal proceedings. So, bago pa magkaroon ng criminal proceedings ay naibigay na ang offended party ang kanyang pardon. But unlike sa pardon ng president, kasi guys, maibibigay yun after the final judgment. Hindi pwedeng maibigay if the case is pending. So next is the Article 37, which tackles costs. What are included in cost? Costs shall include fees and indemnities in the course of the judicial proceedings, whether they be fixed or unalterable, amounts previously determined by law or regulations in force, or amounts not subject to schedule. This article tackles about the costs. So for example, those previously determined by law are the deposit of costs and the payment of lawful suit. These are chargeable to the accused only in case of conviction when the decision is so declares. So in case of acquittal, the cost will be shouldered the official. So the following included in costs are fees, indemnities in the course of judicial proceedings. And also, costs are chargeable to the accused in case of conviction Costs which are expenses of litigation are chargeable to the accused only in cases of conviction. In case of acquittal, the costs are de officio, each party bearing his own expenses. So, na-convict na siya, so sa kanya mapupunta yung cost. But if na-acquit yung case, meaning hati-hati sila, or meaning each party will bear his own expenses. Next, no cost against the Republic unless the law provides the contrary. So there will be no cost shall be allowed against the Republic of the Philippines. So payment of cost is discretionary. The payment of cost is a matter that rests entirely upon the discretion of the courts. Next is Article 38, which talks about pecuniary liabilities. Order of payment. In case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities, the same shall be met in the following order. First is the reparation of the damage caused. Second, indemnification of the consequential damage. Third is the fine. Fourth is the cost of the proceedings. So, kailan nga ba ma-apply ang Article 38? It is applicable in case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities. The order of payment is provided in this article. Hence, if the offender has sufficient or no property, there is no use for this Article 38. Next is the Article 39, and it talks about subsidiary penalties. Subsidiary penalties, it will only be applicable when the conflict is unable to pay the fine. The imposition of subsidiary penalty is not presumed, unlike the accessory na pwedeng i-presume kapag na-render yung judge ng isang penalty. So let's move on to the rule as to subsidiary imprisonment. Number 1, if the penalty imposed is prison, correctional, or arresto, and fine, subsidiary imprisonment shall not exceed 1/3 of the term of the sentence, and shall not continue for more than 1 year, fraction or part of a day not counted. So dito sa rule number 1, kung prison correctional ang na-impose sa offender, which is 6 months and 1 day to 6 years, it is only applicable to the penalty na hindi nag-exceed ng 6 years. Second paragraph, when the penalty imposed is fine only, subsidiary imprisonment shall not exceed 6 months. If the culprit is prosecuted for grave or less grave felony, shall not exceed 15 days or prosecuted for light felony. So, kapag fine lang na impose, dapat ang penalty ay hindi mag-exceed ng 6 months kung grave or less grave felony ang nakomit, and it shall not exceed 15 days kung light felony naman. So sa third paragraph, when the penalty imposed is higher than prison correctional, no subsidiary imprisonment. Sa fourth paragraph, if the penalty imposed is not to be executed by confinement but of fixed duration, subsidiary penalty shall consist in the same deprivations as those of the penalties under the same rules as in number 1, 2, and 3. Lastly, in case the financial circumstances of the convict should improve, he shall pay the fine, notwithstanding the fact that he has already served subsidiary imprisonment. So in summary, there is no subsidiary penalty in the following cases. When penalty imposed is higher than prison correctional, for failure to pay the reparation of the damage caused, in indemnification of consequential damage and the cost of proceedings, when the penalty imposed is fine and penalty not to be executed by confinement in a penal institutions and which has no fixed duration. So next is the subsidiary imprisonment under special laws. The provision on subsidiary imprisonment can be applied suppletorily to special laws pursuant to Article 10, which provide offenses not subject to the provision of this code, offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. Thus, unless the special law provides that subsidiary imprisonment shall not be imposed, subsidiary imprisonment can be imposed for violation of special laws. So, it means that subsidiary imprisonment is pwede siyang maging applicable para sa special laws unless nag-state yung special law na walang subsidiary na applicable sa laws na to. So, by the way, no subsidiary imprisonment for non-payment of income tax. So, walang subsidiary penalty kung wala kang pangbayad ng income tax. Next is Article 40, which is debt. It talks about accessory penalty of debt. The death penalty, when it is not executed by reason of communication or pardon, shall carry with it that of perpetual absolute disqualification and that of civil interdiction during 30 years following the date of sentence, unless such accessory penalties have been expressly remitted in the pardon. So guys, death penalty has been abolished by virtue of Republic Act 9346. So if death ang sentence mo, the accessory penalty na kasama dito are yung perpetual absolute disqualification, civil interdiction during 30 years following the date of sentence. So let's move on to Article 41, which is the reclusion perpetua and the reclusion temporal. Their accessory penalties. Here, the penalties of reclusion perpetua and reclusion temporal shall carry with them that of civil interdiction for life or during the period of that sentence as the case may be, and that of perpetual absolute disqualification which the offender shall suffer even though pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. So it talks about the accessory penalty na kasali kapag nag-render ng judgment na penalty na reclusion perpetua or reclusion temporal ang judge. Thus, a person who is punished with reclusion perpetua or reclusion temporal loses his parental and marital authority, the guardianship over the person, the property of his ward, and the right to manage his properties or to dispose of his properties by any act of inter vivos. So these rights such as parental, marital authority, and others are the rights over civil interdiction. So ang accessory penalty na kasali dito is civil interdiction. Next is Article 42, which is the Prision Mayor. Its accessory penalties. The penalty of Prision Mayor shall carry with it that of temporary absolute disqualification and that of perpetual special disqualification from the right of suffrage, which the offender shall suffer although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. So, this article talks about the accessory penalty na kaakibat ng penalty ng Prision Mayor. So, kapag nag-render yung court ng penalty na principal penalty na Prision Mayor, ito yung mga accessories na included. Number 1 is temporary absolute disqualification. In this case, absolute disqualification means temporary, meaning its duration is coterminous with the duration of penalty. In this case, ang absolute disqualification niya is temporary lang. Meaning, kapag natapos na niyang maserve yung sentence niya na Prision Mayor, mawawala na rin yung punishment niya na absolute disqualification. So, another is perpetual special disqualification from the right of suffrage. This is perpetual, such that unless the disqualification is expressly remitted in the pardon, he is perpetually barred from running for public office and to vote. However, yung perpetual special disqualification is continue pa din siya. Even though natapos na niyang maserve ang kanyang sentence na Prision Mayor, yung accessory penalty niya na special disqualification from the right of suffrage is patuloy pa rin na magsaserve. But there's an exception to the rule. It is unless expressly na nagbigay sa'yo ng pardon ang President. Next is the Article 43, the Prison Correctional. Its accessory penalties. The penalty of prison correctional shall carry with it that of suspension from public office
from the right to follow a profession or calling, and that of perpetual special disqualification from the right of suffrage. If the duration of said imprisonment shall exceed 18 months, the offender shall suffer the disqualification provided in this article, although pardoned as to the principal penalty unless the same shall have been expressly remitted in the pardon. So, this article naman is talking about the accessory of penalty na nakaakibat sa prison correctional. And these are the accessories. Suspension from public office, from the right to follow a profession or calling. Second is the perpetual special disqualification from the right to suffrage. So, sa number 1, yung accessory penalty na makukuha ng offender is yung suspension from public office, from the right to follow a profession or calling. But this suspension is matatapos lang siya until matapos niyang maserve yung sentence niya na prison correctional. Number 2, we must remember that perpetual special disqualification from the right of suffrage if the duration of said imprisonment shall exceed 18 months. Dito, even if na-pardon na ng President ang offender ay magpapatuloy pa din siya sa accessory penalty unless expressly pardoned by the President again. Next is Article 44 or the Arresto. The penalty of Arresto shall carry with it that its suspension of the right to hold office and the right to suffrage during the term of the sentence. So, ang accessory penalty na masasama dito are suspension of the right to hold office and the right of the suffrage during the term of the sentence. Again, right to suffrage is your right to vote and to be voted upon. But the duration of this accessory penalty, kapag natapos mo na mag-serve ng aresto, ay mawawala na din ang accessory penalty na kaakibat nito. So next is the Article 45, the confiscation and forfeiture of the proceeds or instruments of the crime. Every penalty imposed for the commission of a felony shall carry with it the forfeiture or of the proceeds of the crime and the instruments or tools with which it was committed. So this article talks about the confiscation and forfeiture of instruments or tools na ginamit sa isang crime. For example, kapag gumamit ka ng barel na pumatay, ganito, ganyan, na gumawa ng krimen, ay i-confiscate yon ng government. The outline of this provision, number 1, every penalty imposed carries with it the forfeiture of the proceeds of the crime and the instruments or tools used in the commission of the crime. So, kapag nag-render yung judge ng isang penalty sa isang offender, it carries with it the penalty of the forfeiture. Number 2, the proceeds and instruments of tools of the crime are confiscated and forfeited in favor of the government. So, yung mga na-confiscate na tools or instruments ay mapupunta yon sa government and hindi sa police. Number 3, property of a third person not liable for the offense is not subject to confiscation and forfeiture. So, kapag may property na hindi pag-aari ng offender which is nasali sa pag-commit ng crime ay hindi pwedeng kunin yon ng government. 4, property not subject of lawful commerce shall be destroyed. It means naman is yung mga properties na hindi maaaring ibenta or non-beneficial sa isang tao is sisirain siya. For example is yung drugs. Drugs is illegal kaya sisirain siya pag na-confiscate. So, no forfeiture where there is no criminal case. So, dapat, before mag-forfeit or mag-confiscate yung government, dapat may criminal case na na-file or pending. Kasi kapag wala, hindi pwedeng ma-confiscate or hindi pwedeng mag-confiscate ang gobyerno ng basta-basta lang. Bawal mag-confiscate kung walang penalty. Next is, courts cannot order the confiscation of property belonging to a third person if the latter is not indicated. So, yung mga properties na pag-aari ng third person or yung mga innocent person na hindi naman kasali sa offense ay hindi siya maaaring i-forfeit or i-confiscate ng government.
So I think that ends our discussion. Thank you.